Happy New Year and welcome back to the Legal Brief, the show where we crush the various legal myths and misinformation surrounding various areas of the gun world. I'm your host, Adam Kraut, and don't forget, I'm running for the NRA Board of Directors. To learn how you can vote for me, be sure to check out the video that's in the description below. Today we're talking about the Social Security Administration's new regulations and how they may affect gun rights. I've seen tons of people freaking out that the SSA is going to strip individuals of their right to own firearms, but let's go past the headline and find out what's really going on. Cleaning a gun stinks unless you're using Breakthrough Clean's odorless and non-staining solvents and lubricants to tackle your gun cleaning needs. Be sure to check out their military-grade solvent, battle-borne oil and grease, or even the HP Pro for extreme conditions. If you asked and your local shop isn't carrying them, head on over to breakthroughclean.com and use the code TGC10 to get 10% off your order. You may remember some articles over the past 2 years that the Social Security Administration, or SSA, was reporting individuals it deemed incompetent to NICS for the purpose of preventing them from obtaining firearms. On December 19th of 2016, the SSA published its new regulations in the Federal Register, pertaining to those it deems incompetent to handle their own financial affairs. I know a lot of people are only reading headlines these days, so let's explore what the regulations actually say. The part everyone wants to know is how the SSA is determining who has to be reported to NICS. The new regulations tell us under the NICS Improvement Amendments Act of 2007 that the SSA will identify the records of those whom they have adjudicated as a mental defective, which leads to an important question. What does adjudicated as a mental defective mean? The definitions in the regulations tells us that a determination by a court, board, commission, or other lawful authority that a person, as a result of their marked subnormal intelligence or mental illness, incompetency, condition, or disease, is a danger to himself or others, or lacks a mental capacity to contract or manage his own affairs. An important point to mention, the SSA's regulations require that it provide both written and oral notice to the individual at the start of the adjudication process. The individual must be informed that if they are found to be a mental defective, they won't be able to possess guns or ammunition, the penalties for having them, and that the individual has the ability to seek relief. For the purposes of the Social Security program, the SSA has adjudicated as a mental defective any individual who, during the claim development and adjudication process, or when the SSA takes certain post-entitlement or post-eligibility actions, meets the 5 criteria spelled out in the regulation. These 5 criteria for an individual to be adjudicated as a mental defective are: 1. Have filed a claim based on a disability. If the claim wasn't based on a disability, then we don't have to look any further. 2. Has been determined to be disabled based on the finding that the individual's impairment meets or medically equals the requirements of one of the mental disorder listing of impairments. These impairments include things such as organic mental disorders, schizophrenia, paranoid and other psychotic disorders, affective disorders, intellectual disability, anxiety-related disorders, somatoform disorders, personality disorders, substance addiction disorders, and autistic disorder and other pervasive development disorders. I've included a link in the description so that you can see where they are and what they include. 3. Has a primary diagnosis code in SSA's records based on a mental impairment. 4. They have attained the age of 18 but have not yet attained full retirement age. And 5. Requires that his or her benefit payments be made through a representative payee because SSA has determined that he or she is mentally incapable of managing benefit payments. If the SSA has determined that you aren't mentally capable of managing your own financial affairs, then they require the payments be made to a representative of the individual receiving the benefit. If those 5 criteria don't apply to the individual, then they have not been adjudicated as a mental defective for the purposes of the Gun Control Act. Further, the criteria will only be applied to capability findings that the SSA makes in connection with initial claims on or after December 19th of 2017, and capability findings that the SSA makes in connection with continuing disability reviews, including age 18 disability redeterminations, on or after December 19th of 2017. The provisions relating to a continuing disability review will only be with respect to capability findings in which SSA appoints a representative payee for an individual in connection with a continuing disability review. So this doesn't happen until the end of this year. So we see that the SSA has 5 criteria an individual has to meet in order to be determined a mental defective for the purposes of the Gun Control Act. But what about a person who wants to challenge that determination? Well, the regulations provide that if a person is determined to be a mental defective, they may seek relief from the SSA by filing an application for relief. That relief can be requested at any point after the adjudication, and the application will be processed once the SSA has all of the required information. These applications are reviewed by a decision maker who was not involved in determining how the applicant's benefit payments were to be made. So there's a little bit of a separation of power there, and that's a good thing because it's not the same person making the decision twice. The application must include a current statement from the applicant's primary mental health provider, which assesses the applicant's current mental health status, and the mental health status for the 5 years preceding the date, the request for relief, and written statements, and any other evidence regarding the applicant's reputation. The statement provided by the mental health provider must specifically address 1. Whether the applicant has ever been a danger to himself, herself, or others, and 2. Whether the applicant would pose a danger to himself, herself, or others if the SSA were to grant the applicant's request for relief and that applicant purchased and possessed firearms or ammunition. Written statements regarding the applicant's character must specifically identify the person supplying the information, provide that person's current address and telephone number, describe that person's relationship with and the frequency of contact with the applicant, indicate whether the applicant has a reputation for violence in the community, and indicate whether the applicant would pose a danger to himself, herself, or others if the SSA were to grant the applicant's request for relief and the applicant purchased and possessed a firearm or ammunition. These statements can be submitted by a number of people, including clergy, law enforcement officials, employers, friends, and family members, as long as the person providing the statement has known the applicant for a sufficient period of time, has had recent and frequent contact with the applicant, and can attest to the applicant's good reputation. At least one statement must be from an individual who's not related to the applicant by blood or marriage. The SSA can either grant the application for relief or deny it. If the relief is granted, the SSA will send written notice to the applicant explaining their decision, inform them that they are no longer prohibited, and notify the Attorney General that the person is no longer prohibited from possessing firearms or ammunition. If that relief is denied, the individual may seek review in a federal district court. The SSA has 365 days or 1 year from the date of receipt to process an application for relief. The regulations provide for that clock to start once the SSA has received all of the applicant's required information. That would include the statement from the primary mental health provider, as well as the written statement of the applicant's character. So, I know that's a lot to take in, but let me give you an example. Let's say you know a 40-year-old individual who is seeking Social Security assistance for a disability they have. If they submit an application after December 19th of 2017 and the disability is not based on a mental condition, then they need not worry about losing their firearms rights in relation to Social Security payments. If, however, their disability is based on a mental disorder, it is possible they may lose their firearms rights. If, and only if, all 5 criteria that I just mentioned are met. If not all 5 criteria are met, they are not losing their firearms rights in relation to collecting Social Security payments. Unlike what you may have heard, the Social Security Administration is not stripping everyone of their right to own guns because they're collecting benefit payments. Hopefully that gives you a better understanding of what these new regulations mean for those receiving Social Security disability payments and how it may affect their gun rights. If you guys like this episode, you know what to do. Hit that like button and share it around with your friends. Have a question you want answered on the show? Head on over to the legal brief section on theguncollective.com. Be sure to check out my website, adamkraut.com, for more information on my quest to serve you on the NRA Board of Directors. And don't forget to like the Gun Collective on Facebook, Instagram, YouTube, Full30, Snapchat, and wherever else you can catch us on social media. And as always, thanks for watching.
The shirts worn in today's episode of The Legal Brief have been provided by Patriot Patch. Click the link in the description to learn more.